So last week, my client was arrested on one of the most serious charges, murder in the second degree, which carries with it the possibility of life in prison. Prosecutor was required to tell us today if she was indicted and what she was indicted for. Prosecutor refuses to answer a direct question, not only from defense counsel, but from the court. What was Ms. Egea indicted for? Their refusal to answer that question leads me to believe my client was not indicted on murder in the second degree. Fundamental fairness and the Constitution of this state and this country dictates that anyone charged with the crime should know what they're being charged with, what the top count against you is, what you're facing, what you're looking at when confronted with such serious charges. The district attorney's office has refused to answer those questions. The very fact that that question would not be answered by the district attorney's office leads me to believe my client has not been indicted for murder in the second degree. Very simple. If she was indicted for murder in the second degree, the district attorney would have just said so, and I wouldn't be standing here right now. So the fact that they refuse to answer this question leads me to believe that a much lesser charge was brought and voted by the district attorney of Richmond County, a charge which would require my client to be released. But no, my client, who's 6 months pregnant, is being held in isolation and is probably not indicted for murder, is currently being held by the district attorney of this county. That is not fair. That is not America. That is not the criminal justice system that this country is known for and respected for. I said when my client was first arrested that the homicide squad in Staten Island plays fast and loose. Maybe with the exception of one detective, Detective Parker, the rest of them cannot be trusted, and this is exactly why. There's a very, very, very strong likelihood that my client is in remand, not on a murder charge. Why won't the people answer the question? Why won't the district attorney answer a direct question from the court? Why? The answer is because she is not indicted for murder in the second degree. Anyone can see that. It's common sense. Now, they say I was born at night, but I wasn't born last night. She was indicted on something which would require her release, yet she's being held. Thank you.
Mr. Fonte, the judge, you said that the prosecutors are required to tell you what your client's indicted for, but the Supreme Court judge just said that there's nothing in the law that does require prosecutors to do that. So how do you square that away? The
14th Amendment of the Constitution requires that every American citizen be afforded due process and fundamental fairness. And in the world I come from, fairness dictates that you be told what you're being charged with. This isn't North Korea where you're grabbed and you're held and you're isolated and no one knows what you're charged with, and months later they'll come up with some charge. In this country, in this day and age, you should be told what you're charged with. And bail should be set in accordance to that charge. So it's one thing to have bail set on a murder in the second degree charge. It's something much different to have bail set on a Class E felony, which is probably a $50 fine and you're out the door.